Welcome back, everybody. I'm Rebecca Weiss. I'm Head of Trust and Security at Bitkom, and it's great to see you all again today. For all of you who haven't joined us yesterday already, welcome to the Bitkom Privacy Conference. If you didn't join our sessions yesterday, you can watch them later online. The same is true for all the sessions today, so please don't sweat if you can't make it to all the sessions you're interested in. Our program is quite full and our agenda is packed, but yeah, we invite you all to review the sessions later. We also encourage you to make the most of your virtual conference experience and use our different group chats that you can find on the platform, where you can discuss specific questions and connect with other experts from all around the globe. Some of our sessions also include live polls, which you can find on the right-hand side of your screen. I'll check in with you from time to time in the group chat, but if you have any questions or can find anything, please feel free to reach out to me and to my colleagues directly via our platform. I'm very excited that I get to guide you through our program here today on the main stage, which is packed with exciting keynotes and presentations, live interviews, surrounding GDPR compliance, basically. All right, then. Let's get this started and dive right into our first session. Our privacy conference has always been a platform for all stakeholders of the data protection environment: users, politics, businesses, and data protection authorities. Hearing what our DPAs have to say on current issues is of the utmost importance for all of us, because we often look to them for guidance on open questions and how to implement the GDPR. Still, 2 years after it entered into force. So I'm very happy that Barbara Thiel is with us today. She's the Data Protection Officer for Lower Saxony and has been in this position since 2014. She'll give us insights on data subject rights and how they are exercised and what the main challenges are for controllers. It's great to have you with us again this year. Ms. Thiel, the floor is yours.
Thank you. Ladies and gentlemen, good morning to everybody, and many thanks to Susanne Demel for the invitation, and many thanks to you, Rebecca Weiss, for that pleasant welcome. I would like to talk to you, Rebecca said it before, about a topic that has become increasingly important as a result of the European General Data Protection Regulation. The rights of data subjects, this is my topic. Some of them were already familiar to us before the GDPR, for instance, the right of access and the right to erasure or rectification. On the other hand, some are completely new, such as the right to data portability and the right to be forgotten by the internet. Data subjects also have the right to be informed exactly how their data is being processed. Every data controller has a duty to provide information, either under Article 13 or under Article 14 of the GDPR. Next slide, please. Fulfillment of the duties to provide information at the time of collection leads to practical issues. In a digital context, these duties are easy to fulfill. On the other hand, in the common cases of non-digital data collection, this is much more difficult and bureaucratic. In the case of a face-to-face or telephone business transaction, it is unrealistic to expect a data collector to provide detailed information every time he, for instance, takes an order or notes down an appointment. So the Data Protection Conference, in its GDPR progress report, favors fulfillment of these information duties in a staged procedure. It is generally sufficient in appropriate cases to provide just basic information upon initial contact. That is, details of the data collector, the purpose of the processing, and the rights of the data subject. Collectors can then refer data subjects to the additional information on their websites or offer an information sheet. However, there should be no general exemption in order to ensure that the object of the regulation is not contravened, because the information is intended to create increased transparency and thus enable data subjects to assess the legality of any processing of their personal data. Ladies and gentlemen, this is also the intention of the right of access in Article 15 of the GDPR. Let me first briefly explain the restrictions of this right. Next slide, please. The provision of a copy, as stipulated in Article 15, paragraph 3, must not adversely affect the rights and freedoms of third parties. In addition, data collectors may refuse excessive or obviously unfounded requests. The German Data Protection Act, the BDSG, imposes additional restrictions. For instance, if granting the right of access to information would render research or statistical purposes impossible, or if the request contravenes confidentiality duties. There are further exceptions in sections 33 and 34 of the BDSG. And then there are also restrictions which are specific to particular federal states or subject areas. What is important in every case is that the data controller documents the reasons for refusal to grant access. Next slide, please. There are 3 levels to the right of access to information. On the first level, data subjects can request confirmation from the controller as to whether their personal data is being processed. If this is the case, on the second level, the data subject has the right to access this data and various details. The third level is then the right to a copy of the data being processed. Next slide. The GDPR contains various procedural rules on the right of access. The most important are: the data controller must use all reasonable means to establish the identity of the person seeking information. The information must be provided within 1 month. This time limit can be extended by a further 2 months, depending on complexity and number of inquiries. However, in my experience, these time limits do cause problems in practice. If data subjects make their request by electronic means, then they have the right to also receive the information electronically. In addition, the information is to be issued free of charge in principle. Next slide. There are a whole series of issues with Article 15 of the GDPR. This is already controversy about the relationship of paragraph 1, the right of access, to paragraph 3, the right to a copy. And there is discussion as to whether, in the case of a request for information, a data controller must also always automatically provide a copy of the data, or whether the right to a copy is a separate claim which must be specifically formulated. And staying with the right to a copy, some are of the opinion that this claim can be satisfied in the form of a structured summary of the personal data processed. On the other hand, there is a view that a copy always means a reproduction true to the original. It would be helpful if the regulator would clarify this. That's why in its report on the GDPR, the Data Protection Conference recommended clarification of Article 15. Next slide. Ladies and gentlemen, let us now come to the right to erasure. Article 17 of the GDPR states the cases where this right exists. Exceptions are given in Article 17, paragraph 3. According to this, a data subject has no right to erasure of their data if the processing is necessary to comply with the right of freedom, with the right to freedom of expression and information, to fulfill a legal obligation, on public interest grounds in matters of public health, for archiving scientific or historical research or statistical purposes which are in the public interest, and to assert, exercise, or defend legal claims. The right to erasure is also further restricted by Section 35 of the BDSG. Next slide, please. According to the BDSG, in the case of non-automated data processing, there is no right to erasure if this can only be achieved with a disproportionate level of effort and the data subject's interests in erasure is minimal. There is also a restriction of the right to erasure if the controller believes that this could adversely affect the interests of the data subject, and if there are specific conflicts with statutory or contractual retention periods. However, there is debate about whether Section 35 BDSG even conforms to European law, because the wording of Article 17 does not provide for these restrictions of the right to erasure. The Data Protection Conference also criticized these paragraphs in the legislative process for the revised German Data Protection Act. It is also a matter for debate whether a claim to erasure can be fulfilled simply by anonymizing the relevant data. Overall, it is clear that the satisfaction of claims to erasure are error-prone and time-consuming due to the complexity of the right. I therefore highly recommend that data controllers establish an erasure concept to be able to react quickly and stringently to requests for erasure. Next slide, please. Ladies and gentlemen, Article 17, paragraph 2 of the GDPR represents a logical development of the right to be forgotten in the Internet. It obliges a data controller who has published personal data to instruct other data controllers who process this data to delete all links to the data or copies thereof. This should ensure, for instance, that certain articles or copies of these can no longer be found through search engines. However, just at the end of July, Germany's Federal Court of Justice ruled that there was no automatic right to be forgotten. Courts must instead decide in individual cases whether the interests of data subjects or the public are more important. Personal rights versus press freedom and freedom of opinion. The Federal Court of Justice has thus qualified the decision of the European Court of Justice from the 13th of May in 2014. In this, the European Court of Justice establishes a fundamental precedence of the right to be forgotten. Next slide, please. Finally, I would like to say a few words about the new right to data portability under Article 20 of the GDPR, provided the lawfulness of the processing is based upon consent or a contract in accordance with Article 6, paragraph 1, letter B. Data subjects have the right to receive the data in a structured, commonly used, and machine-readable format, and to receive the data either themselves or have it transmitted directly by one data controller to the other. In my view, this right is as yet seldom exercised, but still there are a few issues to be resolved. For instance, there is a debate about which data is covered by this right. Is it only the data actively provided by the user, or also that generated from the study of usage behavior, what is known as metadata? Moreover, it has yet to be established what formats are actually suitable in practice for transmitting the data. That's all from me. Thank you for listening.
Thank you for giving us such a broad overview on the data subject rights, which are pretty important for basically every controller, because implementing them is still kind of a struggle, I might say. We had some questions in our group chat, especially regarding situations where many controllers at once are contacted on the basis of Article 15, and we had the question whether if a user reaches out to me and wants his information to be given, whether I have to give every email out where basically his name is printed in. I know that we don't have time to address these questions right now, but if you post those questions in the group chat, I invite you all to join the session after the next one as well, because it will feature especially those questions, and we'll try to find an answer there. But now, thank you, Ms. Thiel, for joining us again this year for your presentation. I hope to see you again soon. Have a lovely day.
Okay, thank you very much and have a good day. Bye-bye.
Bye.